Hello class, welcome to Chapter 6, Obtaining Information and Intelligence. The objectives we're going to cover in this chapter are: we will identify the sources of information that are available to investigators, explain what the goal of interviewing and interrogation is, explain the different types of questions used during interviews and interrogations and when to use each. Describe how to conduct interviews when multiple people are at the scene. Compare and contrast approaches that are used to appeal to reluctant interviewees. We will explain what the Miranda warning is and when it must be given. Describe the various techniques used in an interrogation. Explain what significance a confession has in an investigation. Describe what a polygraph is, its role in investigation, and its acceptability in terms of results in court. We will also differentiate between information and intelligence. The knowledge that is obtained through questioning is on equal par with physical evidence. They are equally important. Questioning can provide leads for finding physical evidence. A confession, if it's provided, must be supported by physical evidence or other corroboration. There are three primary sources of information available in addition to physical evidence. Those are reports, records, and databases, including those found on the internet, people who are not suspects in a crime, but who know something about the crime or are involved to some degree, and then, of course, the suspects in the crime itself. There are numerous sources of information that exist, and they often overlap. This file contains the name and location of people, organizations, and records that may assist in a criminal investigation. Let's talk about the information age. We are truly living in the information age, and it is a period in which knowledge and information are increasing exponentially, literally by the minute. Computerized information is much more available now to law enforcement entities, and the information can be accessed in the squad car now almost immediately. When it comes to reports, records, and databases, there are local resources which include police department records, reports, files, etc., laboratory and coroner's reports, banks, loan and credit companies, delivery services, hospitals, hotels and motels, personal departments, and so forth. There are also inventory tracking systems, caller ID, pen registers, and dialed number recorders. There are state resources that are available, such as a specific state's Bureau of Investigation. That's just one example. And federal resources are available, and they include the U.S. Postal Service, Immigration and Naturalization Service, Social Security Administration, the FBI, Federal Bureau of Investigation, the Bureau of Alcohol, Tobacco, and Firearms, the ATF, and Drug Enforcement Administration, DEA. And you also have as a resource the FBI's National Crime Information Center, NCIC, it's often called. It goes without saying that the internet is the greatest single valuable source of information in the history of mankind. But it can also be used to aid in an investigation, because it can be used to distribute photographs and details and information quickly. A couple of sites used often in investigation, a couple of prominent sites, are the website of International Association of Chiefs of Police and the FBI's website. But there are many others that are of equal import. They're far too numerous to list here. You have information that you gain from victims, complainants, and witnesses. Investigators should interview the victim or victims, complainant or complainants, and witness or witnesses. Sometimes a search is needed to locate these individuals. Some techniques to gain information is the neighborhood canvass, the knock and talk, where you go from door to door, like for instance in a missing persons investigation, or something that occurred that neighbors might have witnessed, etc. Now, a note of caution: be aware that the suspect and witness statements are not always reliable. You'll have 3 witnesses that say that the perpetrator was wearing a red baseball cap and 2 that say he was wearing a black baseball cap. So it's not always reliable. But we'll talk a little more about that further down the road. An informant is anyone else that I didn't just list who can provide information about a crime. Investigators should be extremely careful in using such contacts. They can be playing both sides. Sometimes they're unreliable. You also have confidential informants. These are informants that are formally registered. They're compensated by the department. They supply information or perform a specific service. And building trust with a confidential informant is key when you're developing an informant and working with a confidential informant. In terms of establishing reliability when dealing with confidential informants, the investigator must be able to establish the reliability of the informant and establish the totality of circumstances necessary to establish probable cause. You want to corroborate as much of the informant's information as possible, determine how, where, and when, and under what circumstances the informant obtained their information, provide or reveal statements that informants have made, and identify the informant if it is safe to do so. Of course, your suspect is going to have the most information, and a suspect is defined as a person considered to be directly or indirectly connected with a crime, either through his or her own actions or by planning or directing it. Any suspicious persons should be questioned. A field interview is when questioning occurs spontaneously on the street. Keep a record of the field interview. Sometimes the investigator will choose to gather information from a suspect through undercover or surveillance officers or various types of listening devices. The ultimate goal of interviewing and interrogation is to determine the truth, that is, to identify those responsible for a crime and clear the innocent of suspicion. Information is obtained continuously throughout an investigation, so individuals may be interviewed or interrogated multiple times. An interview involves a discussion with someone who is not a suspect, but they do know something of value to a case, versus an interrogation, which is interrogating someone who is suspected of direct or indirect involvement in the crime itself. Some characteristics of an interviewer or an interrogator are someone who is adaptable and culturally adroit. In other words, they can easily converse with people from a wide range of socioeconomic backgrounds. A good interviewer and interrogator or interrogator is self-controlled and patient, confident and optimistic, objective, sensitive to individual rights, and knowledgeable about the elements of crimes. Communication can be enhanced by preparing the interview in advance, obtaining information as soon after the incident as possible, being considerate and friendly, using a private setting, eliminating physical barriers, sitting rather than standing, encouraging conversation, asking simple questions one at a time, and then listening and observing. Some barriers to communication during an interview or interrogation include emotional barriers, where someone has ingrained attitudes and prejudices, fear, anger, or hostility, or the person being interviewed has the instinct for self-preservation, so they just close down and are uncooperative. Some other barriers to communication are language barriers, individuals who are hearing impaired, individuals who have Alzheimer's or some form of dementia perhaps, or individuals who are mentally impaired in some fashion. To provide effective questioning techniques, there are two basic requirements for obtaining information, and they are to listen and observe. Now, some guidelines for effective questioning are: ask one question at a time and keep your responses simple and direct. Avoid questions that can be answered with yes or no. Avoid closed-ended questions like that. You want to ask open-ended questions which elicit information or conversation from the person being interviewed. Be positive in your approach. Give the person time to answer. Listen to answers, but at the same time, anticipate your next question. Watch your body language and tone of voice. Start the conversation on neutral territory. Tuck any tape recorder behind a portfolio or notepad, as the use of it can be frightening to anyone being interviewed. This is why interview rooms now, or ones that have been built in recent years, have cameras built in, and it's not obvious, and it's not recording devices sitting right on the table in front of the person being interviewed. React to what you hear. As you move into difficult territory, slow down. Don't rush to fill silences. Pose the toughest questions simply, directly, and with confidence. Establish professional demeanor and keep your role clear. Now, types of questions are direct, indirect, closed-ended, open-ended, and leading. A direct question is to the point and allows little possibility of misinterpretation. An indirect question is a question that can be disguised. It can be useful in eliciting details. Closed-ended questions are what I mentioned just a moment ago, and they can be answered yes or no with another short, simple answer, and this type is generally avoided. Open-ended questions give the victim, witness, or suspect the opportunity to provide a full response, allowing the investigator great insight into the person's knowledge and feelings. A leading question prompts or leads a person to a specific response and often implies an answer. Ask direct questions and open-ended questions liberally. Leading questions also can have a useful interrogation purpose, and then remember to use indirect and closed-ended questions sparingly. Repetition is important. Repetition is an effective technique for improving recall and uncovering lies. Someone who is lying will either provide very inconsistent stories or will tell a story exactly the same way each time, as if it is well rehearsed. Because in truth, they have rehearsed it. to the point that they have taught themselves word for word every line. A truthful story will contain the same facts but be phrased differently each time it is retold. In regards to recording and videotaping interviews and interrogations, some states require that interviews be recorded. Some states are videotaping interviews rather than recording them. The benefits of tapes are that they provide a verbatim account to verify accuracy of a report. It frees the investigator from taking copious notes, and that if an investigator is consistently writing, they're not able to focus on the person they're questioning as effectively. Again, also, if they are using tapes, it allows the investigator the chance to review the conversation as often as needed and pay closer attention to body language and nonverbal cues. And taping also ensures that detectives do not stray into third-degree tactics, take unethical lines of questioning, or engage in any conduct that violates the rights of those being questioned. Some criticisms of mandatory recording policies are that such techniques might deter confession, and some people might refuse to speak freely. Before conducting an interview, you want to establish a priority of obtaining statements. If possible, you want to interview witnesses in this order: the victim or complainant first, then eyewitnesses, and then people who did not actually see the crime but have relative information. In most cases, the interview is done with the complainant first. Make sure to record both positive and negative information. You need to do some advanced planning before conducting an interview. Review reports about the case. Learn as much as possible about the person you are going to question. Know which questions you need answers to, and have a plan of approach to likely responses. You also need to make sure when you're selecting the time and place, sometimes there is no time to decide where and when. For instance, if things are happening quickly at an unfolding scene. But if you're able to select a time and place, like an interview room, and you ask someone to come in at a specific time, and so forth. Witnesses are best able to recall details immediately after an incident, so you want to interview someone as soon as possible, someone related to the incident as soon as possible. Witnesses are less likely to embellish or exaggerate because others present can be asked to verify the information. Witnesses also can be separated so they cannot compare information. Sometimes there is a reluctance to give police information, but it is usually not as strong a reluctance immediately after a crime has taken place. The beginning of the interview is very important to the overall success of the interview. Make your initial contact friendly but professional. Begin by identifying yourself and showing your credentials. Then ask a general question about the person's knowledge of the crime. You want to establish good rapport with the person you're interviewing. It is the most critical factor in any interview. Rapport is an understanding between individuals created by genuine interest and concern. Find a way to motivate every witness to talk with you and answer your questions. Careful listening enhances rapport. A network is a body of personal contacts that can further one's career. These networks also establish relationships between people and their beliefs, and officers need to understand the networks in their jurisdiction. Sometimes you're dealing with reluctant interviewees. Try to appeal to a reluctant interviewee's reason or emotion. Use reason to determine why the person refuses to cooperate and explain the problems that can result when people who know about a crime do not cooperate with investigators. The emotional approach addresses negative feelings. You can increase these emotions or simply acknowledge them. The cognitive interview tries to get the interviewee to recall the scene mentally by using simple mnemonic techniques aimed at encouraging focused retrieval. For this, you need a secluded, quiet place that is free of distractions, and you need to encourage a subject to speak slowly. As the interviewer, you need to help the interviewee reconstruct the circumstances, encourage the interviewee to report everything, and ask the interviewee to relate the events in a different order or to change perspective. Some drawbacks to this approach are the amount of time it takes and the need for a controlled environment. Now let's mention testimonial hearsay. Police reports should differentiate between statements that resulted from structured questions and those that did not. If an interview yields substantial information, a statement should be obtained. Otherwise, it is just ruled hearsay and is inadmissible. The reason I said you need a statement is the actual statement is a legal narrative description of events related to a crime and is therefore admissible. The statement includes identification of the person, his or her account of the incident, and a clause stating that the information was given voluntarily. When closing the interview, thank the person for cooperating. If you have established good rapport, that person will probably cooperate with you later if needed. Let's get into the interrogation itself. It is critical to ensure that you do not violate a suspect's constitutional rights in an interview so that the information you obtain will be admissible in court. The Miranda warning informs suspects of their Fifth Amendment rights, and it must be given to every suspect who is interrogated while in custody. And there are instances when Miranda does not apply. It does not apply to voluntary or unsolicited, spontaneous statements, admissions, or confessions. It is not required during identification procedures such as fingerprinting, taking voice or handwriting examples, or conducting a lineup or sobriety test. It is not required during routine booking questions, during brief on-the-scene questioning, or during brief investigatory questioning during temporary detention. It is not required during roadside questioning following a routine traffic stop. It is not required by probation officers questioning those on probation. And it is not required during questioning by a private citizen who is not an agent of the government. There are times when people can waive their rights. A suspect may waive the rights granted by the Miranda warning, but must do so intelligently and knowingly. A waiver is accompanied by a written or witnessed oral statement that the waiver was voluntary. Silence is not a waiver. The effects of Miranda are that the basic intent of the Miranda decision is to guarantee the rights of the accused, but the practical effect is to ensure that confessions are obtained without duress or coercion. Miranda can be challenged and often is in court, but has withstood the test of time, as many rulings have been made about the constitutionality of Miranda. Now, it can be challenged in individual court cases as well, in terms of when it was given to someone and so forth, or whether or not it was given at all. Now, the question first or beachheading technique are techniques that exist, and one example is an officer questions a custodial suspect without giving the Miranda warnings and obtains incriminating statements. The officer then gives the warning, gets a waiver, and repeats the interrogation to obtain the same statement. In Missouri v. Siebert in 2004, the Supreme Court found this technique to be unconstitutional. Now let's talk about the interplay of the Fourth and Fifth Amendments, where someone can, in the Fourth Amendment, they're protected from unreasonable search and seizure, and in the Fifth Amendment, they have the right to remain silent. However, in New York v. Quarles in 1984, the Supreme Court ruled on the public safety exception to the Miranda warning requirement. In a 5-4 decision, the Supreme Court found that the jurisprudential rule of Miranda must yield in, quote, a situation where concern for public safety must be paramount to adherence to the literal language of the prophylactic rules enunciated in Miranda, end quote. The rule of Miranda is not therefore absolute and can be a bit more elastic in cases of public safety. So it means that in a particular case involving public safety, the need to have the suspect talk in exigent circumstances takes precedence over the requirement that the defendant be read his rights. Now, the right to counsel exists, of course, under the Fifth and Sixth Amendments, and at any point, once a Miranda warning has been given, the suspect is free to maintain their silence and ask for representation and is not obligated to speak beyond that. In terms of foreign nationals, they have the right to refuse to be questioned under the Vienna Convention of 1963 because they have diplomatic immunity and therefore are not subject to the laws in the United States. Conduct interrogations in a place that is private and free from interruption. Ideal conditions exist at the police station where privacy and interruptions can be controlled. When you start the interrogation, you want to show that you are in command. Watch your nonverbal communication. In other words, don't be overly passive or overly aggressive. Maintain a professional presence and maintain control. You want to provide time for anxiety to increase. As you enter, again, show that you are in command, but do not display arrogance. Determine your interrogation technique. Increase or decrease the suspect's anxiety by how you, or depending on the interrogation technique that you use. And we'll talk about those techniques later. You want to make sure that you do not overlook body language or nonverbal communication that may indicate deception, anger, or indifference. You also, of course, want to show your identification, introduce yourself, state the purpose of the interrogation, and give the Miranda warning. Earlier, I mentioned establishing rapport. Show or demonstrate that cooperation from the subject being interrogated is desirable. There are approaches to interrogation. You can inquire directly or indirectly. You can force responses, deflate or inflate the ego, minimize or maximize the crime, project blame. You can use rationalization, or you can combine approaches. I'm going to discuss using persuasion during an interrogation now. There are persuasive techniques that you can use, and they are as follows. Make sure the suspect is comfortable. Acknowledge that there is a problem that exists, which is why they're there. But first, the suspect needs to be informed of their rights. Suggest that the suspect probably already knows all about these rights and ask him to tell what he knows, then compliment him on his knowledge. This builds rapport. Next, encourage the suspect to tell his side of the story in detail, then review the account step by step. Begin a virtual monologue about a specific crime, describing how no one starts out planning a life of crime, but how some fall into a criminal pattern that leads either to getting shot and killed or spending a lifetime in prison. Next, suggest the suspect can avoid this fate only by breaking this pattern, and that the first step is to admit that it exists. Add that a person's life should not be judged by one mistake, nor should that person's life be wasted by a refusal to admit that mistake. Finish by talking about the fairness of the criminal justice system and how judges are likely to go easier on suspects who indicate remorse. Point out that intelligent people recognize when it is in their best interest to admit mistakes. There are what are called crime questionnaires, and these are an alternative to a face-to-face interrogation. The crime questionnaire is a document with 21 questions that test for truth and deception. It can be used in conjunction with a polygraph or in situations where a polygraph cannot be used. Supporters of this method believe the questionnaire shows considerable accuracy in predicting guilt or innocence. I'm going to talk now about ethics and the use of deception. Although law enforcement officers are expected to be honest, the Supreme Court has recognized that their duties may require limited, officially sanctioned deception during a criminal investigation. There are several cases that support officer use of deception. Interrogatory deception may include claiming to possess evidence that does not really exist, making promises, misrepresenting the seriousness of the offense, misrepresenting identity, for example, pretending to be a cellmate or a reporter, for example, sorry to be redundant there, or using the good cop, bad cop routine. Some interrogation techniques, even if they're not illegal, may be unethical. Above all, professional behavior remains important. Third-degree tactics include use of physical force, threats of force, or other physical, mental, or psychological abuse to induce a suspect to confess to a crime. They are illegal. Any information so obtained, including confessions, is inadmissible in court. When it comes to admissions and confessions, an admission contains some information concerning the elements of a crime but falls short of a full confession, whereas a confession is information supporting the elements of a crime given by a person involved in committing it. A confession can be oral or handwritten, but it must be given of the suspect's free will and not in response to fear, threats, promises, or rewards. A confession is only one part of an investigation. It must be corroborated by independent evidence. An adoptive admission occurs when someone else makes a statement in a person's presence and under circumstances where it would be logical to expect the person to make a denial if the statement falsely implicates him, but he does not deny the allegation itself. Special considerations exist when questioning children and juveniles. Parental permission must be obtained before questioning a youth. Often juveniles will not feel comfortable being honest if their parents are present. Do not use a youth as an informant unless the parents know the situation. Remember that many juveniles put on airs in front of their friends. Juveniles may have definite opinions about the police as well. However, do not underrate young people's intelligence or cleverness. They are often excellent observers with good memories. If a juvenile confesses to a crime, bring in the parents and have the youth repeat the confession to them. They will see that the information is voluntary. Do not accept information obtained from interviews and interrogations at face value, because often the information provided to the police is only partially truthful. Corroborate or disprove statements made during questioning. To break a pat story, ask questions that require slightly different answers that will alter memorized responses. This allows the story to become distorted and mistakes and exaggerations come out. There are scientific aids to obtaining and evaluating information. Probably the most familiar to everyone is the polygraph and voice stress test. The polygraph scientifically measures respiration and depth of breathing, as well as changes in the skin's electrical resistance, blood pressure, and pulse rate. The polygraph is used to verify the truth, not as a substitute for investigating and questioning. Although the results are not presently admissible in court, any confession obtained as a result of a polygraph test is admissible. So, for example, if someone denies an accusation, they take a polygraph, they clearly failed it, and then you say you did not pass your polygraph, and then they confess to everything. The polygraph itself is not admissible, but the confession is. There's also hypnosis and the use of truth serums. These are supplementary tools to investigation, not used as shortcuts. Hypnosis physically induces a trance-like condition in which the person loses consciousness but responds to a hypnotist's suggestions. This is used with crime victims and witnesses to crimes, but not with suspects. The court guidelines for using testimony gained from hypnosis require that a trained professional perform it and that the professional be independent of, rather than responsible to, the prosecution. Truth serums are fast-acting barbiturates of the type used to produce sleep at the approximate level of surgical anesthesia. They're not used extensively by the police because the accuracy of the information obtained with them is questionable. It's actually highly questionable. Courts do not officially recognize them or their reliability, nor do they admit the results as evidence. Let's mention the use of psychics and profilers. First, psychics. Although controversial, some agents are willing to consider any possible lead or source of information, including psychics, in a criminal investigation. Profilers, however, are professionals, and effective profiling relies on the profiler's ability to combine investigative experience, training in forensic and behavioral sciences, and information about the characteristics of known offenders. There can be substantial obstacles that prevent police agencies from sharing information, including competing local systems, incompatible data formats, issues of who controls the data, security questions, cost and training time and resources. There are services that allow very good information sharing, and one of them is CJSCM, or Global Justice XML data model, and it has become the national standard to allow agencies to share information with each other. You also have the National Criminal Intelligence Sharing Plan, or NCISP, and one DOJ, which is run by the Department of Justice, and Law Enforcement National Data Exchange, or INDEX. We were just speaking about sharing information, but there needs to be a differentiation between information versus intelligence. Information or data is not intelligence. Information plus analysis is intelligence. And there are centers called fusion centers that exist, and they are used to exchange information and intelligence and merge data from many sources to provide a much larger intelligence framework and a much more comprehensive picture of all sorts of crimes, suspects, etc. This helps apply good analytical skills when using intelligence versus just strict information. To summarize what we discussed in this chapter, remember the ultimate goal of interviewing and interrogating is to determine the truth. There are two basic requirements to obtain information, and they are to listen and to observe. Interview anyone other than a suspect who has information about the case. Special considerations are also observed when questioning children and youths, and we discussed those. And we also discussed how you can sometimes use scientific aids. Okay, class, that completes Chapter 6. Thank you, as always, for your attention. And as always, be sure to contact your instructor should you need any clarification or need any help. Again, thank you for your time, and we will meet again for Chapter 7.